Haki mkononi. Grievance procedure and institutions to approach. If an employee is not a member of a trade union, he or she should present their complaint or grievance to the immediate supervisor. If there is no action taken, the employee should set an appointment with management. If the matter remains unresolved, then the employee should file a complaint at the nearest Labour office. However, sometimes the employee is forced to go straight to the Labour office or the industrial court. If an employee has been dismissed unfairly, he or she should present a complaint to a Labour office within 3 months of the date of dismissal. The Labour officer will give an opportunity to both the employer and employee to give their side of the story and give recommendations on how to settle the dispute. The employee also has a right to go to the industrial court to present his complaint. If the complaint is because of a contractual agreement, the complaint should be filed in court within 6 years. If it is because of injury at work, then the complaint should be filed within 3 years. An employee under probation or who has been summarily dismissed while under probation cannot complain at the Labour office or at the industrial court. The employee must be able to show that he or she was unfairly terminated, and the employer must be able to show the justification for termination. Note: at the industrial court, you do not need an advocate to represent you. You can be represented by a trade union representative, or you can appear in person, that is, self-represent. You can also hire an advocate if you want. Remedies for wrongful dismissal and unfair termination. Where there was no notice given, the employee is entitled to the salary he or she would have earned had he or she been given notice. Where an employee is dismissed before the contract is over, and the contract was such that the employee gets paid at the end of the contract and after completing his or her services, the employee is entitled to 1. Payment for work done until the time he or she was dismissed. 2. Payment for losses incurred as a result of the dismissal. 3. Payment for losses arising between the date of dismissal and the date of expiry of the notice period. 4. Money he or she would have earned had notice been given. Where an employee is unfairly dismissed, he or she may 1. Be reinstated and continues to work like he or she was never dismissed. Or 2. Not be returned to his or her original position, but may be given similar or suitable work and be paid the same wages. They may be re-engaged. Before any recommendations are given, the Labour officer or industrial court consider the following. 1. The wishes of the employee. 2. The circumstances in which the termination took place, including if the employee caused or contributed to the termination. 3. If it is practical for the employee to be reinstated or re-engaged. 4. The employee's length of service with the employer. 5. The reasonable expectation of the employee as to the length of time for which his or her employment might have continued had he or she not been terminated. 6. The opportunities available to the employee for securing similar or suitable employment with another employer. 7. The value of any severance payable by law. 8. The right of the employee to claim for any unpaid wages or expenses. 9. Any expenses reasonably incurred by the employee as a consequence of the termination. 10. Any conduct of the employee which to any extent caused or contributed to the termination. 11. Any compensation, including ex gratia payment paid by the employer and received by the employee. For more information on your labor rights, write to info@kituochasheria.or.ke or SMS 0700 777 333.